All right, welcome everyone to our MUI training today. We are glad that you are here. We have our entire investigative agent team on the call today that will be running our meeting today, so that's very exciting. We're grateful for them. Just a couple of housekeeping items. If you would keep yourself on mute unless you have a question. When there's time for questions, feel free to unmute and ask them. There's also the chat box where you are welcome to put in questions you have. We'll have a question and answer section today. We're hoping you have questions. We encourage questions today, so feel free to start thinking of MUI related questions that you have, so that we can help get those answered for you today. There will be a training certificate available for today's course that you can receive. At the end of our training today, there will be a link put into the chat for you to follow and fill out a short form that will then initiate that certificate to be emailed to you. So you'll need that link. So make sure to stay on the call for that to receive that. All right, I'm going to turn it over to Rebecca Lyons.
Okay, I'll actually share my screen. I'll try here. Let's see if this works. Let me pull this down. Okay, can you see my presentation there? Okay, perfect. So I'm so glad everybody was able to make it here today. This is the last in our provider series on MUI topics. So if this has been helpful, drop us a note. If there's anything you want to see in the future or any resources or help you need, always reach out. We're happy to help you. Really quick, I wanted to go over some common acronyms, things that we use in jargon every day and might not be so familiar if you're a new provider or new to the DD world. A quick system overview, and then I'm going to open it up to the panel. Very excited to have our IAs here to answer your questions. So some common acronyms that I came up with here are the OIR, that's the Office of Incident Review. We don't use that too often, but if you hear that, that's our Butler County term for our MUI department. I've heard other counties use Department of Safety or MUIP, prevention team. Here in Butler County, it's the OIR. MUI UI, it's a major unusual incident. You guys have those trainings every year. DD, of course, developmental disabilities. IA is a rule term for an investigative agent. It's a DD investigator. OISP, Ohio ISP, ISP, IP, there's a lot of terms for that. That's the Ohio Individual Service Plan. You guys meet with your teams every year to come up with this. This is your contract as a provider, that you understand what the person needs and what you can provide to help them. The SSA, again, that's a rule term for a support coordinator, service coordinator in Butler County. We use the rule term. We call them service and support administrators. The individual is always the person receiving DD services. And similarly, when we talk about a peer, we're not talking about a school peer. We're not talking about community neighbors. We're talking about another person who also receives DD services. So those peer-to-peer incidents are always involving two individuals who receive DD services. The PPI is our primary person involved. This is the perpetrator. So it's only for certain cases where there's an allegation of abuse or neglect, something where someone was named as doing something adverse to our population. If you're filling out your incident report for an unscheduled hospitalization or anything like that, that PPI section, you can leave it blank or put NA. We don't have a perpetrator in those cases. When we talk about the state or DODD, that's of course Ohio Department of Developmental Disabilities. They oversee all of us. LE, we refer to law enforcement or police notifications as LE sometimes. BCCS, that's our term for Butler County Children's Services. I've also heard them called CSP. There's a lot of terms. CPS, 241 kids. There's a lot of terms for them. In Butler County, BCCS, when you see that, it's going to be Children's Services. OITMS, that's the Ohio Incident Tracking and Monitoring System. That's the platform where we enter our MUIs and reports. That's also the system where you as a provider can set up an account and get your yearly data. If you need help with that, just reach out to Amy or Kathy or myself. We can help you. Staff, we're always referred to, when you see staff in a report, that's paid staff. There's a lot of terms for it. It could be direct care staff, DCS, PSP. A lot of agencies use different titles. So We try to go with the titles that the providers use, but if you see staff, that's what that means. A couple others, these are specific to IAs. This is our jargon between us. So if you see this in an email, it might, we try not to do this with providers and outside, but if you see sub or unsub, that's substantiated, unsubstantiated, those are our outcomes for that case. UBS, I always use this for unapproved behavioral support. It's just a whole lot easier. If you hear UBS, that's what I'm talking about. The rest are categories too. RCV, PA, UH, the P2P, we use that as shorthand. BX is behavior. So for asking for behavior documentation, you might see that shortcut. Same with TX. I've seen that as training. I've seen it as treatment as well. Kind of depends on the context. If it's medical, I think that's a medical term, TX. Same with MAR or PO, medication administration record, physician's orders. A lot of times we ask for things and we just shortcut it. So if you don't know what we're asking for, please, just let us know. Okay, I'm going to go on. Okay. The goal of the MUI, I wanted to give kind of an overview in this training. So the goal that we're all here for is to protect the health and welfare of individuals supported in Ohio. It's a quality improvement process, and we need your participation in reporting accurately and timely. But also you guys have the eyes on these individuals. Like, we don't know them per se. So when we're trying to build a support around them and help them not have these adverse incidents in the future, we're trying to prevent that. And we need your input to help us enhance their quality of life and give them better outcomes. So we're all in this together. It's not an adverse system. We're not here to try to get you. Yeah, just cooperate. What is an MUI? So that's an allegation, a suspicion, or an actual occurrence. There are 19 categories in the rule, depending on how you count them. We do administrative investigations. We're not doing criminal work. So we're not coming out to interrogate people. We're not coming out to press charges or arrest anyone. We don't have those powers. Our outcome, we're looking for a preponderance of the evidence. So when we have to give a disposition, whether something is substantiated or not, we're looking at that low level preponderance of the evidence, 51%. Is it more likely that this happened or not? And if it is, we'll substantiate. If it's not, we won't. Okay, our categories are divided into kind of 3 levels. So the highest level, Appendix A, these are more serious. They're criminal type cases. We'll have police or children's services sometimes. These are our abuse, neglect, theft, exploitation, all of those. These are the ones that require that disposition, that outcome. We have to substantiate or not. So at the end of this, our PPI will get a letter to let them know of our outcome. You guys will get a summary that will also describe the investigation. Appendix B is our mid-level. So these are things that happened. There's no dispute of facts. We're not saying we have to substantiate or not in these cases. You will get a summary at the end, but these are things that really do need that prevention. They need that extra support. The attempted suicide, injuries, medical emergencies, all of those mid-level range MUIs. And lastly, Appendix C. Again, there's no dispute of fact here. We file when they happen. The law enforcement, the UBS, and the hospitalizations. And our whole purpose here is just to, again, look at prevention. If it's a UBS, we're looking at maybe including that in the plan so that next time we won't have to file. Okay, we've looked at this slide many, many times through our trainings. It all starts with that incident. If it meets one of those 19 categories, I'm going to file it. We'll make sure the immediate actions are set, that the person is safe. There is some action taken. It could be first aid, it could be calling police or putting staff on leave. It depends on the case. So when I get these incidents, I will go ahead and file them in OITMS, our platform. I will assign an investigator and I'll send you out a notification, and that will let you know that on this date, this happened. We filed this category for this person. Here's the IA assigned. I might provide some extra details or information we need, but at that point, it carries over to the IA who's assigned. They'll complete their report, gather their information, and enter that back into OITMS. The whole goal of our system is for prevention planning. So we want to know, why did this happen, the cause and contributing factors, and how can we prevent it? So those are things that are part of our system. In Butler County, we have our director is Kara Frederick. We have 5 IAs here. Of course, I'm intake, so I'm doing that filtering and filing and assigning. We have Patrick, Ralph, Mike, and Amy. Fantastic IAs. I'm so glad they're here. We get to hear from them in a little bit. And then we also have Michelle Truitt in our department, who helps us on our medical cases. As a provider, if you have any medical questions or need any help or support, absolutely reach out to us, reach out to Michelle. She's fantastic. I wanted to pull this up. So last year, just to give you an idea of what we're dealing with, here in Butler County, we filed 586 MUI categories that were assigned between the 4 IAs. I bring this up just to give you a picture of how much work we're dealing with, how many cases we have. And I wanted to highlight the stakeholder meeting, which is next week after the provider meeting. I hope you guys can hang out and attend that, learn a little bit more about that 586 that we dealt with this past year. So, all right. That's all I have for the MUI overview. It's a quick flyover, so I'm going to send it back to Kathy, if I can unshare, stop share. All right, Kathy, all yours. You're muted, Kathy.
Thank you. Sorry about that. Thank you for that overview. Now we're at our fun part of our meeting today. We're excited about this. We are going to have a panel of questions. We have some questions prepared, and we will be hopefully getting some questions from all of you in a little bit. So we've divided some questions into a few categories. So I'm just gonna ask our IA to help answer these questions we have. So our first section of questions is about the investigative process. So our first question is, how do you arrive at a conclusion for your cases?
I think I'm up for that.
Patrick? Yeah.
Morning, everybody. How do we arrive at a conclusion for our cases? Part of it, you know, probably think about our process somewhat, that, you know, we're gathering all of our information. The investigative agents are required to do all the interviews for our investigations when they're category A, you know, abuse, neglect, misappropriation, and such, unless children's services or police are head of those investigations or doing them. If we're doing them, we do our interviews. You know, we're to talk to the individuals, everybody that's involved that can have input, seek medical opinions, all of that. So we're gathering all the information. We're to look at all, you know, schedules or people there. We might be asking for medical records, your MAR, definitely like witness statements from the staff after we've interviewed them and such. So once we've gathered all of our information and we're looking at our conclusion, we do have a very prescribed format that we use at the state. You know, for each case, there's incident-specific questions that we're looking at for physical abuse. You know, how hard was, you know, was there any, you know, how hard was it, and such. So we're looking at all these pieces, and really it's preponderance of evidence in part that we're looking at. So that's part of that, probably the next question that we're coming up with. But when we arrive at our conclusion, we're really looking at those steps that we go through for the cases, and they're pretty extensive, you know, that we have to make sure that we've reviewed everything and that we have all the information, and we talk to each other a lot. So, you know, we don't do these in a vacuum, trying to come up with our conclusion. But we're supposed to be, you know, very, you know, straightforward, well succinct. So if there's, I'm not sure where to go next.
Yeah. Yeah, you kind of led into this other question we have, which is, what is the burden of proof for our investigations?
Yeah.
Like you touched on that.
And that's preponderance of evidence. That's the 51%. Becca touched on that for Mint and hers as well. So we only need 51%. So it's one person's word against another. Then
yes. Also,
Shannon, can you mute? Sorry.
Again, it's preponderance of evidence. It's one person's word against another, then that's 50-50, then, we would to substantiate to say that something more likely than not has occurred. We just need that 1%. So if it's alleged physical abuse and you got one person's word against the other, there's no injuries, nothing else to confirm this. There's nothing to disprove it because we also have, our levels are substantiated, unsubstantiated, insufficient evidence to prove, and unfounded. So unfounded is that mean it absolutely couldn't happen. It's very clear that there's nothing that's that would even the person that they're accusing definitely was that person, and they're not even working that shift or were on or anywhere around, and we had witnesses to prove that or something. It has to be very, very strong to be unfounded. But however, to say it's substantiated, we only need that extra 1%. So if somebody says, well, they hit me on the arm, and then they have a matching fingerprint red marks on there or something of that nature, that could be our 1%. It could be, credibility or just anything else that, might support that. So again, it isn't really out there to say, oh, I got you, or to get you in trouble. It's just like, yeah, we need to make sure that this is, taken seriously. And again, all of our investigations really should be focusing on the prevention piece. Like I said, these aren't criminal, but we'll get to it later. We do want to make sure they're very thorough investigations because they could lead to the abuser registry. A lot of times those are criminal cases or such, but you need to make sure your cases are very strong. So you might have beyond our preponderance of evidence, and then we need to support that, make sure we've talked to all of our witnesses and gathered all that information so that we can, help support that process.
Okay. So how long will the investigation take?
Well, I believe we get roughly 45 days of the system when we actually file it. So if you've reported it to us and we have till once we're in we could be in discovery trying to gather some more information. Is this reasonable to have occurred? Normally we're doing that within the first day or first 24 hours. So we know right away, typically, we're going to file, or we might have to ask a few extra questions if it's very vague, that's comes in. So we have till 5 p.m. the next business day, I believe, to file this at the state. And then once that's started, that starts our timeline of the 45 days. Now, they all don't take that. Some take longer, some take shorter, but that's the first section of time that we deal with, and we should try to get that resolved within there. So it kind of varies. If somebody's on leave, we're going to try to do that as fast as possible to get that resolved. Other cases, might be a hospitalization. We definitely kind of want to wait till the person gets out, see what their next follow-up appointment is, so that we have a little bit of a story to tell between, what happened and how did it get resolved. So you don't want to, necessarily always close those immediately. There might be times we have to extend a case, which we can, normally in 2-week blocks, but it could be a law enforcement investigation. They haven't come to their conclusion, or the person still trying to get a hold of witnesses or documentation or such. So it really depends, but we're on a very short time frame when we're talking about, say, abuse and neglect, that we need to commence that investigation within 24 hours, which it can be simply as we're starting to review the documentation, but we're to start talking to the individuals within 3 working days, and start with the witnesses and such. So, it should be, fairly quickly that we can get a preliminary out. Typically, it is in the rule that, I don't know if that's later, but physical and sexual abuse require us to come up with a preliminary outcome to review with the individual, the guardian, and the provider. Even if we don't know exactly what it is, we should be talking. So state definitely wants us to, keep that open communication so what's going on. And if you don't and you haven't heard from us, definitely call, if we've forgotten to touch base. So I don't know if that helps.
Yeah, that's great. And providers and staff, they can help make that process go smoother by cooperating and getting back to you in a timely manner and all of that, I'm sure, right?
Mhm.
Yeah.
Definitely, and that's part of the, even in the rule, used to be the old rule long ago, they had like 5 days to respond to us. They kind of took that out and left, yes, something you to get back with us within a reasonable amount of time. Obviously, if it's something we're requesting medical records and we have to get a consent still for it, and then and we don't have that record and you don't have it, and it's like, well, we're asking for the hospital or something, so that may, take some time. But things that we're requesting, sometimes that 5 day is still kind of that general guideline. So if it goes weeks and we're asking for extensions, so we're beyond the 45 days and we still haven't got a witness statement back from a staff we interviewed 3 weeks ago and asked for, because, sometimes if we've called them, normally we'll try to meet with the primary person involved and such. And at that point, we should try to get them to fill that out then and there. But if they're on shift or something of that nature, we'll, you can get that back to us. Those should be given it a, a timely manner, and they're required to cooperate with the investigation. So we can't just let that go. At some point we'll have to get back and say, hey, they're not cooperating or such. So that's something we see sometimes, is trying to get that piece of information. A lot of times it's witness statements and stuff like that, documentation.
Okay. Awesome. I think we have time for one more for you. Can I do my own investigation with an open MUI or police investigation?
Yes, the rule allows you to do your own investigation. I would probably contact, if you're going to be talking about interviewing the staff or such. A lot of times these were considered like HR or those type of, you try to get that just enough information for you for your own policies and procedures. But I would, if you're talking to, the witnesses, I'd be very careful, maybe contact us first about what questions you're going to ask or stuff. This is not, it would probably help our investigation, but if there's a police investigation involved, be very careful about what you're saying and leading, because that can affect their outcome and their investigation. And so we don't want to interfere with that, but definitely you can do your own investigation. If you do your own investigation, you're to tell us, and you have 14 days to give us the outcome in writing of what that investigation was in detail, so that we have that information, or you can allow us to do it as well.
All right, thank you. Great information. All right, our next section is notifications. I think we have Ralph on deck for this one. So my question is, when do I need to file a police report?
All right. As cases come in, depending on what they are, it depends on what you need to do. When are you required to file a police report? Is when there is a crime involved, and that usually involves a physical abuse, a sexual abuse of some sort, or a misappropriation, which is basically a theft. If something is missing for the individual, that may need to be filed for the police or to the police. And it's our job to make sure that that notification is made, but it is normally the staff's job to make the initial report to the police when they become aware of it. Also, if an incident occurs at a developmental center like SODC, then when you call the police, it's supposed to be the police that has jurisdiction of where it occurred. If it occurred in Fairfield, then you call the Fairfield police. If it occurred in Hamilton, you call the Hamilton police. If it occurs at a developmental center like SODC, then the highway patrol needs to be notified. And if the victim or the individual who's affected by this crime is under the age of 22, then the Department of Children, the Department of Children's Services, I'm from Florida, we call it something different, is notified also. Okay, so those notifications need to be made as soon as possible or immediately.
Okay, Thank you. Why do police cases take so long?
That's a difficult question. When I was writing out the answer, you know, as a retired police officer, it depends on a lot of things. It depends on the time of day. It depends on how busy it is. Like an afternoon shift, for instance, it may take the officer responding to the home or to make contact hours. It may not. Also, from my experience doing this job, some officers or some detectives are better, I guess. You know, they'll respond quicker and do things quicker for us. But it all depends on what's happening. Also, when a case is assigned to a detective, eventually he's got to put this case together after he's done all the interviews, after he's collected all the evidence, taken all the pictures, done what he needs to do. He then has to present it to the prosecutor. And then the prosecutor, depending on how busy they are, how serious the case is, will also take some time in getting back to you with the answer. And that, again, can take weeks. It can take months. I mean, sometimes we've got to take extensions. As my partner here said, we have to wait for the outcome, the results, and for us to decide what needs to be done next. So if it takes past those 45 days, we may have to take an extension, waiting or pending the outcome of the police investigation. So it can take a while. Some cases are easier done. Some cases are take longer. But it's once it's in the police hands, it's then.
Okay. So when do I need to use the Butler County Board of DD on-call system?
Okay, normally under normal hours, 8 a.m. to 4 p.m., Becca, our intake person, is called directly. If it happens that the case occurs after 4 p.m., we have an on-call system, and the number, if you don't have it, is 513-867-5913, and you report it to them. And that on weekends, on holidays, we're here 24 hours a day. So again, between 8 and 4, it's directly to the intake people or intake person, which is Becca. Or if it's after 4, then you contact the on-call, which is whoever, you know, the support coordinators take turns, and whoever it is, but you report it to them directly. Do not just leave a message. Do not just leave a text. Do not just leave something on the computer, because we have these time stamps that we have to meet by code, by the rule. So you need to let us know as soon as possible. Then it goes into if it's a case, if it's an A category or a category A, it has to be reported immediately, and to us no later than 4 hours. If it's a category B or C, then you have to 3 o'clock the following day. But be careful with that, because it puts us in a bind, in that then Becca has to file it by 5 p.m. and she normally gets off at 4. So she'd like to get those called in as soon as possible. Okay, so that's it. That's all I got.
All right, thank you. Great info. All right, our next series of questions are related to disagreements with the county board. So we have Mike up for this one. First question I have is, what if I disagree with an immediate action step suggested by the county board?
All right. Hey, so I mean, hopefully there's no disagreements, right? No. So what we usually find, well, obviously, I think we've touched on some of it already with the immediate action steps. I think Patrick touched on some of that, but well, Ralph did too. When we're looking at immediate action steps, a lot of those are going to be around those kind of physical abuse, sexual abuse, misappropriation. Everyone's really good at the future action steps. So we want to come up with action steps to protect that health and welfare of someone. What are we doing to move forward to potentially not have this thing happen again. But what are those immediate action steps? What is the thing we're doing right now, kind of reasonable measures to look after that health and welfare and make sure that that risk is being looked at right there and then? And we've already said, we're administrative review. We don't have arrest powers. And when we do look at physical abuse, sexual abuse, those types of things, that's where some of the disagreement comes in, because a lot of the times we're saying, hey, and this is usually our go-to, which some of you probably know, our go-to is usually remove that staff until potentially the morning, gives us time to get in there, talk to that person, talk to the individual, and at least protect them for the night, and also protect you as a provider, because what if it did happen and you've left them in there? Now, if it didn't happen, you've covered all the bases. So it allows that to happen. And that's where we sometimes see that disagreement. Providers are going, but that's the only staff I have, and I'm going to have to send another staff back in, or I'm going to have a manager go in. But we're looking at not only, again, saying that again, protecting the individual, also protecting you. And that's that disagreement we sometimes see the most when those on-calls come in and support coordinators are calling us and we're saying, well, that staff has to be out. So sometimes that's that disagreement. But going back to that, on those types of cases, saying that we don't have arrest powers, again, like Ralph said, on those cases, we're calling the police anyway. And potentially the police are going to come in and say, get that staff out of there. So you could have that disagreement with us, but it might also be the police that are coming in and saying, hey, that staff needs to come out. And I don't think people generally argue with the police on that. So that's just one of the areas where people argue. Not argue, but disagree. That's a wrong word, Mike. Other action steps where people disagree, I would say a lot of the medical side, that medical piece, and we do, we push on that a little bit if it's that immediate action step, if it's truly needed. And somebody says, hey, but we've got a doctor's appointment next week, but we know that those appointments haven't been met, and we're saying, no, they need to go to the hospital right now. That's an immediate action step. They need to be seen right now. Yes, there's an appointment next week, but go to the hospital right now. And that's not a hard thing to do. Just put someone in a car, call 911, call an ambulance. It's an immediate action step, right? For that, we're not sure why there's disagreement sometimes, but that's a hard one to call on why there's disagreement. So a lot of our folks, or if not all our folks, okay, not all of them, have Medicaid. Okay, they've got someone who can pay for those services to come and look after them. The health and welfare is looked after, get them the services they need. But yeah, so I guess we'll have questions on that at the end, possibly.
Okay, you covered it great, I think. What if I get a summary and I disagree with the outcome of the summary?
So we get through all of the cases, all that stuff that kind of Patrick talked about, and the summary comes to you. At the bottom of the summaries, I've got one pulled up here, so I can tell you all about it. But it does specifically say, if you dispute the findings of this report by submitting a letter of dispute and supporting documentation to the county board superintendent or to the director of the Ohio Department of DD, and that is if the department conducted the investigation, you would send it to them. So it also says you have 15 calendar days to do that. And those are the specific things that are on that summary. I point to the screen over here that you can't see. So yes, people may disagree. I don't know how often that actually happens. Becca might know, but usually we're talking to the teams. Patrick brought that up. We're talking to folks throughout it. We're getting our investigations completed by speaking to team members, to providers, to individuals. We're gathering evidence. We're taking pictures. People are involved throughout it. So again, I don't know how often people disagree with the summary, but hopefully, because everyone's involved, everyone is aware of what the findings are going to be. So it shouldn't be a huge surprise when that summary comes. But some people do just disagree throughout, right? So if they do, again, look at the bottom of those summaries when they come. It is on there. You're right to do that. That you can submit your findings yourself and your documentation, put it in writing. And again, you have 15 calendar days. And then you'll get a response from the superintendent with her writing back, and she'll disagree or agree with what you're coming back at us with. So it's all on there. It's written out for you. And potentially people have never looked at the bottom of the summary because you look at the findings and get annoyed and disagree. But it's there.
Yeah, good to know. That's great. I have one last question for you then. My staff was named as a PPI and the case was substantiated, but I don't believe that is accurate. Is there an appeal process for PPIs at the county board level?
So there is no formal process. But the PPI can discuss those specifics. And I was informed myself that they can call the QA director, so Kara, if they feel something's been missed or not considered, that sort of stuff. And depending on that case, so Patrick mentioned the abuser registry, which I believe we're going to get to as well, coming up a little more in depth on that abuser registry. So depending how that PPI has been listed, if that case has decided that the state has decided that PPI on that case will move to the abuser registry side, there will be a little more formal process at that level. But at our level, on that county level, it's more of just a discussion, and it doesn't move anywhere on our level.
All right, thank you. Well, you mentioned the abuser registry process, so that's our next section, actually. I guess it looks like Patrick, he unmuted, he's taken this section for us. So my first question with this is, who decides how someone gets on the abuser registry?
That's at the state level, DODD. There is the investigators, there's 3 throughout the state that do MUI investigations when there's conflict of interest. Normally these, we have Steve Sizemore assigned to our area, and he normally reviews, they look at every single case that we have where there's, it's substantiated that it's the potential. So they review all of them. We don't do any recommendations of that. We just submit our cases. They just have our investigation report to start with. And when they review that, they think, is that strong enough? So if we're talking, oh, this is preponderance of evidence, more likely than not, this person, did this, and there's no harm, there was no injury, but there's potential or risk there, they're probably not going to look at, that level. They're looking for very, and it might be for the next one, they're looking for very strong evidence for it. So there's a police case or something of that nature. So they're definitely going to, like I said, review those, and then they'll ask a little bit for that process. They're going to ask us for our full case. They want our witness statements, everything, all of our documentation. They may ask for a few more things and contact numbers. They may actually want to speak to some of the witnesses or the individuals to start that process. So once their committee looks at them and they think it's strong enough to move on to the next step, that's when they're going to consider it, and probably people will get notified they're being considered, and that hearing process can take place. Other times it's a little more automatic that it's a criminal process, and there's been times where we've had cases where we've gone to the prosecutor, said, hey, part of the deal is we want the PPI to go ahead and put themselves on. So they'll sign that they're volunteering, you know, to put themselves on the registry as part of the plea deal for the case or something of that nature. But yeah, that's done at the state level.
Yeah,
Over that one.
Yeah, you kind of went to my other question. I don't know if there's anything else you wanted to add to that about the burden of proof. What is the process or burden of proof for the abuser registry?
Yeah, we talked a little bit about the process there. The burden of proof is definitely clear and convincing. So those cases where you have multiple witnesses, they're strong, we've got all their statements, they're standing behind it, they're looking at it. Like I said, it's not necessarily that one person's word against the other. You still have, I mean, we've had cases where there's only been one witness, but it's, the physical evidence is there, the police investigation or something might be backing that as well. So, that's why we want to make sure, some cases may, you know, not be that we might not think are that strong or some. That's why on our side, we will make sure every case is as strong as possible and not just say, oh, we got this person who's saying it and that's just enough to wrap it up. But no, we need to talk to everybody else to make sure that we've got, a really strong case if they do consider it. So they have that ability to review it and consider it.
That kind of leads to my next question, which is how long does the abuser registry process take?
I would say just this kind of personally, we don't get a lot of those requests of those. I forgot how many we had at the top. Becca, what? I've been doing those. We have over 500 cases last year, and like one or two of our cases sometimes get picked from that. So once they review it, like I said, if it's a criminal investigation, that might move faster, but it's normally a lengthy process. If it's longer and there's hearings involved, that's like any other court proceedings. I've seen those drag out for a year or more. But typically we kind of know within 6 months, maybe or so. We get those updates pretty regularly. Like I said, if you have that really strong criminal case, it's already through, there's already a conviction. Yeah, that's probably going to move much quicker than it's one of our cases. The police weren't involved and stuff, and they're trying to do it on the witnesses. They're up there gathering that case just like we did. They're re-interviewing, making sure, the lawyers have, everybody's looked it over from their end that they can get through that hearing process if they want to appeal it to begin with. So yeah, I'm not sure. Becca knows a little bit more. Like I said, it's not really set, and we've had cases.
It's not. It sometimes takes years to get someone on the abuser registry just because they have a formal process in place. They have appeals. It's a formal hearing. And it varies case to case. Some get on immediately. Some PPIs takes a while to get them there.
Yeah, that really answered. Claudia had a question in the chat. You addressed that. She was wanting to know how long it takes when someone's involved in an incident and then when they get placed on the registry, and then what keeps them from going to another agency and work there until their name shows up on the registry.
If we know that for sure, and even in the process of those immediate actions, somebody is being removed for alleged, physical abuse, we haven't got it, but we know they work for another agency. That process for us, even, we don't run until we'll tell the state, our regional manager, Chris Young, and then he'll contact that other provider, depending on, the seriousness of the allegation or what evidence there, and maybe let them know. But that doesn't necessarily mean they're going to stop working at that other provider. It just depends on what's happening there. So, at this level, again, the abuser registry, once you're on it, is the only process that's going to stop them from working. There's nothing out there, if we've substantiated those cases and they're not on the registry, physical abuse, or the provider may, by their policies and procedures, let the person go. A lot of times we see them go to another company and start, and we can't say anything to that other company that we have, we've substantiated these cases because they're not on the registry, and our burden of proof is only 51%. So we can't, that's the only mechanism in place to stop. So we do see people job hopping, you know, and we see repeat incidents coming up. That's definitely something we can try to, you know, hope that, you know, the process is everybody's monitoring, but we really can't do much about it. You know, again, we could go to the state and they could see if they would do, but a lot of times I haven't seen where that, you know, anybody's been stopped again. It's only the registry. You know, we have a hard enough with notifications. Those cases too, you know, people ask, oh, it's been substantiated against my staff, or the PPI is asking what happens with this. You know, this record really lives just with the individual in their medical, you know, in their records here. It's not something anyone else can look at, even the SSAs necessarily. They're overturn. It's, we can see it, the state can see it. We can look at past MUIs, and we do look at that and look at different PPIs and such, and we might see that history pop up, but nobody else has access to that. So it's really just kind of locked into that. And again, like I said, we don't have that, you know, we're not looking criminally for that. We're mainly say, okay, what's the preventative plans? What's happening here? But it sometimes is kind of hard to see a staff or someone who's continually either suspected or led or actually been substantiated job hopping from agency to agency, county to county.
Yeah. All right, one more quick question for you, Patrick, is do staff have the ability to appeal?
Yeah, there's when you'll get the staff that they just don't appear on the registry, they're going to get notified that they're considered to be placed on the registry, and then they have the ability to have a hearing process before that even happens. So that's where the state's going to build their case, and then you go through that entire appeals process. So that's again what may take a long time, because it's a very formal court. Clear and convincing evidence is going to be needed to get somebody on there.
Okay, thank you. All right, next section is about the PPI process. We have Amy up for this section. My first question is, my staff has been named as a PPI and I need to place them on administrative leave. What should I say or not say to them?
Good morning. Okay, so if you have, one of your staff members under fire, or, you're putting them on leave, you can have a conversation with them. You don't need to give them the specific details of the incident or overshare, but you can say that an allegation has been made. You'll be contacted soon. They're trying to figure out what really happened, what's going on. And that just to avoid any contact with the individual immediately, don't, call them, don't reach out. And then I would just tell my staff that, not to take this personally, that these allegations happen often, and that it's just, a health and safety. We're here to protect them and the clients.
Yeah, great. What if I'm aware a PPI for one of my homes also works for another DD agency?
You can definitely let your IA know, notify the county board. If it's an allegation of a physical or sexual abuse, that's something that, needs to be notified right away, any MUI, but especially those. And then, we can reach out to that other agency if needed. But I would just, cover your own and notify, and then let the county handle it from there.
How do I know if a staff I am hiring has an MUI history?
You can check the abuser registry. Pat just talked about the abuser registry. That is ultimately what is going to determine if somebody is able to work in our field or not. And then you can also check their references, ask them directly. And then the county board, we are not able to confirm or deny any previous MUI history. That is not something that we are able to share with providers.
All right, thank you for that. I have a general question. I guess I'll throw it out to all of you, whoever wants to take that, related to the whole MUI process, and that's why do county boards seem to operate so differently?
I could take that. So there's a couple of differences that I've noticed between county boards. There's 88 counties in Ohio. We have the same rule, but you know, we carry a different caseload than other counties. We have a lot more MUIs than some, we have less than others. So organizationally, we're set up a little bit differently from county to county. You might have some who want you to report MUIs a certain way, and that's just based on the staff that they have. They might have like just one line, it might be covered by 3 different IAs or something like that, where we have an intake system. So we see those kind of things. There's counties that ask for all of your UIs, regardless of, they just want to review all of those. And those counties have staff to review them. Butler County, we don't, so I'm not going to ask agency providers for every UI. Please don't send us those. And that's a difference I see. Another has to do with maybe if you're reporting something, one county will file it, they'll assign an investigator and it'll be an MUI. Another county, they may see it differently and they may not file it. So those are kind of differences in interpretation. DODD does set out a guideline, interpretive guidelines for us. Butler County, we try to be pretty strict and stay with DODD's interpretations. Other counties may not, they may have more cases coming in. So they may do a little bit of triage at the front end. And send some of those through the UI process. I'd say there's not necessarily a right or wrong. In Butler County, I try to be consistent and transparent. So if you are ever wondering what the thought process is, why did this not get filed, or why did you file here and I didn't see it filed over there, I'm happy to talk with you on any of those. One specific difference I have with DODD, but I'll go with them, is on their idea of unanticipated for the hospitalizations. My idea would be maybe 30, 60 days in advance, you know, it's coming, it's anticipated. But their thought is if you have a birth defect and you know that person's going to need surgeries through their life or hospitalizations, that's anticipated. So that's a different interpretation, right? So what they're asking us to file is more than what I would, just based on my understanding of the rule. So I'll go with them, even though I somewhat disagree. Other counties, they may not. They may go with the 30, 60 days. That's anticipated. That's just one example of many. The rule is, there's a lot of gray in there for how you interpret things.
Mm-hmm. All right, we have a little bit of time left. If anyone else wants to unmute and ask questions, this is our time. If you aren't comfortable talking, you could throw them in the chat and we will hopefully get time to answer them.
Kathy, I'd like to just add something really quick. Before, at the beginning of this, we were talking about that our agency handles almost 600 MUIs per year. And we have 4 investigators, so that's about 125 apiece. We're pretty busy because it isn't just getting the MUI, it's actually writing a 5, 6, 7, 10-page report of all your findings. The other thing that was brought up too was that some of the providers were interested on whether they can conduct their own investigation, and you were told that absolutely, there's the rule provides it. Whatever information you are able to obtain, like photographs, statements, we need those copies. It isn't just for your investigation. We're also going to require it for ours. And because we are so busy, sometimes we need, if we can get that stuff sent to us when it's done without having to request it, or, and I've run into this a couple of times, that you'll ask a direct care provider for a statement because they were there when the incident occurred. We're not getting it right away. Sometimes we have to ask for it 2 and 3 times. And that slows us down for the next case that's pending. So we would appreciate any help in getting these things done in a timely manner. It helps us move along. Okay, so that's it.
That's great, thanks. Anyone else? Any questions for our team? I have put the link in the chat to follow that link to go and get your certificate as proof of your training. for credit for that. We'll hang tight for maybe just another couple minutes and let you go. You can always feel free to reach out to any of our IAs or Amy Winkler and I to get your questions answered too, if you think of some later that you didn't have a chance to ask today.
I have a question.
Yeah.
What if a provider or other witness just flat out refuses to cooperate?
Again, in the rules, they're required to cooperate with investigations. So if it's paid staff, there we've definitely had this before where we're going to contact the provider and say they have to cooperate. We've had cases where I had the PPI eventually just stopped cooperating with the investigation with the police, and then the provider just moved forward. And it's either you cooperate or you can't work. You know, they have to either remove them from the schedule, or eventually the person was terminated because they refused to cooperate. So it is required. You can't just say, I'm not going to give you a statement. I'm not going to interview. So when we do that, we expect them, you know, there's to, again, cooperate, and the provider needs to support that as well, or we start taking it to, you know, the next level. If the provider is also supporting them and allowing them to continue to work, then we're going to go with provider compliance, because it's definitely in the rule and mandated.
Okay.
Great question. Anyone else?
Kathy, I wanted to respond to Claudia again on her question. What keeps someone from going to another agency when they have substantiated abuse or neglect or something, but they're not quite on the registry? I would say if you have any specifics or specific concerns, you can definitely bring those to our attention. We can talk with DODD and see if there's more we can do. It kind of depends on the severity of the case. I agree that does leave vulnerable clients when we're kind of waiting on this sometimes lengthy process to get a person who should be on the registry there. But if you have any specifics, again, just let us know.
All right, well, I think that is a wrap. Thank you all so much for coming. Thank you to the IAs for being here and answering all those tough questions for us. I guess we'll let you go. Don't forget to use that link to get your certificate there in the chat. Have a great day, everybody.